Okay, so here we are, chapter 5, turning to the forensic expert. So they start off by reminding the reader that DNA evidence, in fact, doesn't really come up in cases very often, and so the forensic expert is not frequently called on to testify. Anyway, they say material and forensic evidence becomes meaningful only in the light of the testimony already presented to the court. So here we have something of a new development. In previous chapters, we've seen that both the nurse examiners and victims' testimony could really only gain their credibility in the light of data doubles. Whereas, they say, the forensic scientist, removed from the context of evidence collection, created a sanitized scientific narrative about the nature and meaning of its recovery. Hlavka and Mulla chart out the relationship between authority and the forensic scientist's testimony and its sanitized quality, saying that in contrast to the nurse examiner's testimony, which might include details about the victim's demeanor and emotional state, the scientific scientist worked, quote, with evidence collected by others, transformed into an artifact of law that transcended the emotionally fraught reality of the victim witness. The forensic scientist's intervention also allowed for the transmutation of corporeal evidence into the clinical language of proteins and DNA. In short, forensic scientists used sanitizing language that did not dwell on the origins of the examination findings. And so further, the forensic scientist's era of authority in court was the product of collective preparation and processes, but presented in the singular I, in spite of the we standing behind the testimony. Now, in this section, Hlavka and Mulla open by noting how the sort of quantitative evidence that forensic scientists offer can be overvalued in a trial, either because of its absence in the face of expectations or because it can dwarf other testimony. They borrow the term truth machine to capture how DNA evidence and impersonal numbers can convince jurors as yet unprepared to be persuaded by sworn testimony. This occurs in spite of the rarity of DNA evidence and that it's generally unhelpful to prosecution when it is available. In the majority of the cases, the suspect is already known to the victim, right? So stranger sexual assault is in fact quite a rarity. And so DNA is not really relevant in most cases to identifying the suspect. And even then, it only tells who was involved. It says nothing at all about the legal question of consent. Rather, they say, it simply corroborated the fact of sexual conduct. Nothing about the nature of that conduct. The question they want to pursue then is what sort of storyteller a forensic scientist is. Aware of jurors' expectations, informed not the least by a multitude of TV shows, forensic scientists always wore a suit to testify, and prosecutors would begin by establishing her expert status. So we've seen this pattern now in the author's accounts of all of the witnesses, at least the professional witnesses so far. Police, nurse examiners, forensic scientists, where they account not just for the way that the prosecutor will establish the particular expertise, the particular relevancy of each of them, but also how they present themselves. so that the attention to dress is something we note in each of these cases. Why? Well, because these are culturally, symbolically potent ways of presenting oneself, speaking to the expectations that jurors may have, or at least that the witnesses anticipate jurors to have. The forensic scientist, they say, would never sound rehearsed, and in fact, as a legal storyteller, the forensic scientist relied on a scripted speech that she had mastered and was able to deliver in a seemingly spontaneous fashion, right? So that the part of the training then is to get the script down, but to be able to deliver it in such a way that it doesn't sound like it's being rehearsed from memory, that it's in a sense becomes incorporated into the forensic scientist as witness. A persistent theme in the chapter's account of forensic scientists is how they projected confidence, seeming to feel at home in the court and on the stand. So, for example, knowing how to get to the stand without needing direction, entering and conducting oneself in the courtroom as if directly at home there, not feeling any kind of hesitation or uncertainty about where to be and how to comport oneself. This aura of confidence and authority had the effect of validating racial categories, as forensic scientists would use these kinds of categories to explain statistical probabilities. Indeed, they would use these to try and make the probability of a particular DNA profile belonging to a particular defendant intelligible, transparent to non-experts. But they would not explain the disconnections between genetics and race in a way that would educate the jury to recognize that these didn't just line up in a neat way. The scripted preparation of the forensic scientist rarely, but importantly, raises questions of bias. So a report from the National Forensic Science Technology Center concluded that the Wisconsin State Crime Laboratory operated not as this kind of neutral, dispassionate scientific organization, but rather as an arm of law enforcement. As part of their professional training, forensic scientists stage mock trials to cultivate testimonial confidence in anticipation of being called to the stand, even though it rarely happens. So that a lot of their work has this kind of anticipatory quality to it, on the assumption that in any case they could be called to the stand, even though it's not commonplace. That is, then, their expertise is not simply on the scientific side of their work, but in performing as convincing legal storytellers. If the forensic nurse pushed the victim's body into the foreground, as we saw in the previous chapter, and had little or nothing to say about the victimizer's body, we get sort of the reverse here with the forensic scientist, whose testimony presents the defendant's body, for example, as manifest in a DNA profile, while saying really nothing much about the victim's body. An important aspect of the forensic scientist's presentation of the victimizer's body that contrasted with the nurse examiner's clinical and physical and often emotional attachment to the victim was her matter-of-fact demeanor. So they say of the forensic scientist, the affective labor that the forensic scientist performed was key. With cool detachment, she generated a clinical portrait of the defendant's body and trace secretions that were likely found on the victim's body. The cultivation of a clinical demeanor had its counterpart in strategies to sanitize testimony. For example, substituting a word like saliva with the saliva-borne enzyme amylase. So this is a way of sort of heading off the possibility of jury disgust reactions at hearing talk of saliva, when instead they can use the drier, less evocative term amylase. Strategies of this sort were collaborative in nature, right? So it's not like each forensic scientist had to come up with a strategy like this on her own, but that the preparation, like the scientific work, was collaborative in that forensic scientists would share their experiences with one another and would give each other feedback on testimony, and indeed would help each other prepare for the stand. The obscuring of the forensic scientists' collective work, both just the nature of science where the work itself is collective, but also with the preparation as storytellers, by presenting an I in court that rested on the work of a we, was in part the product of the adjudication structure and the rules around hearsay, right? So that a forensic scientist would get on the stand and wouldn't be able to reference conversations she'd had with other scientists in the lab. That would count as hearsay, but rather would have to present what she could speak to as the one who analyzed, say, a sample. Outside of the courtroom, however, forensic scientists talked of their work in the plural, we. So, for example, when the authors interviewed forensic scientists for their project. So they would speak of the collaborative nature of their work, that being the nature of science, and in terms of their professionalization as potential witnesses. Although this collaboration could include prosecutors' feedback on testimony and sharing trial outcomes, an aspect of the professionalism forensic scientists cultivated was their careful presentation of neutrality, right? So despite what the report cited earlier indicated, the forensic scientist would present herself as a neutral party, as if to say, this is what the science has to say, I'm just reporting on what the science has to say. The plural then would arise during testimony when the forensic scientist talked about general crime lab practices, as might arise when the scientist would educate the jury about protocols for handling and analyzing DNA, as if to say, these are the protocols, we all follow these protocols, so in this particular case, I follow the protocols that we all have as just standard practice. In no small part, the authority of the forensic scientist relied on, the authority that the forensic scientist relied on to educate jurors rested on their credibility, itself a product of their ability to testify persuasively without having memorized a data double, her report, which she would in fact have consulted immediately before entering court. They say, consistent use of the first person singular, not first person plural, throughout the remainder of her testimony reinforced the impression that it was the forensic scientist who held the relevant knowledge pertaining to the case, while the collective we established that her mode of knowledge projection was produced within the normative standards of a reliable and respected community of forensic scientists. Here, they say, wait, do I have something before this? Yes, I do. Okay. So now, we've already seen early on that forensic scientist testimony solidified the idea of a genetics-race connection. So the authors say, though they used the terms Caucasian, Asian, and Hispanic, they did not explain whether these categories were genetically meaningful. Forensic scientists allowed the unexplained object of race to stand in for the complex demographic category they referenced, allowing race to harden and naturalize as genetically determined. This could lead to juror confusion, especially when the forensic scientists shifted between probabilities that a DNA profile matched someone in a database, so people who had actually been tested and whose samples had been recorded in a database, versus the public at large, not all of whom obviously have been tested, and so that would require a certain kind of extrapolation. They write, forensic scientists understood that the racial categories they mobilized were not genetically distinct subcategories, but rather were proxy variables, for example, for a geographical locality. The problem with failing explicitly to caution against equating race with genetics was that it allowed jurors to maintain notions of biological race. Now, they summarize the argument of their chapter like this. The successful presentation of DNA evidence was as tethered to the perception of the fidelity of its scientific rigor as it was to the expert ways in which it was made legible for juries. The forensic scientist could not give away the performative nature of her legal storytelling role for the DNA evidence to be taken as scientifically authoritative. Statistical probability was produced through a series of figures that appeal to lay people who make up the jury. The science that was explained to the jurors was selective, leaving intact their popular imagining of a genetically simplistic racial marker. Thank you very much.